I want to read a part of a case I found on Google Scholar. So my friend who was a pro se litigant, Rob Yitzty, when he got hit by a car and then he got accused of a DUI on a bicycle, which was the most important thing to prosecute after a year of no court proceedings after COVID. And Judge McIntosh didn't even know he was on a bicycle. She was like, he was on a bicycle? And you guys are bringing this case forward? Like, what? So anyway, he was like, are you doing your research on Google Scholar? And I was like, okay, I'll do my research on Google Scholar. So guess what I found? I found State v. Lissy. And I'm going to skip through the gory details of the introduction of the case and get to this history of the legislative intent of 165.540. There's another case, it's something to do with PGE, which chronicles how much legislative intent can influence, is it PGE v. Boley or Boley v. PGE? That's like, I think is that Portland General Electric? But it's a Bureau of Labor and Industries case, which I was like, oh, this is cool. But I think it's pretty important to understand, because one thing I'm pointing out to the district attorney and the prosecutor is one-party recording on a phone call pertains to complicated phone calls, which I thought there would be no case law precedent to even establish why that was necessary. But State v. Lissy is really interesting because it actually shows that the parties involved in even, say, a ransom phone call where a police is listening on it's actually a police power. Like a ransom kidnapping phone call, having a recording of the ransom taking phone call when you have multiple parties working together, you don't even have to have a notification that a cop is listening on the line while this person is trying to extort you for ransom. So, as I said to Officer Hansen, when he tried to come up to me, and I have no idea why he put this case forward, I have no idea why the chief of police did not veto it, I have no idea why they think they should prosecute women for going to a domestic violence center, I have no idea why they're giving Ozark Iraq immunity to discriminate for this long, and I have no idea why they're not seeing the forest for the trees. I don't. But it is very important to look at the I think it's important to look at the legislative intent of this. State v. Lissy describes the 165.540, how it starts as a very small statute, then it gets added on and built up and built up and built up, and then look at, because I've been looking at it through the lens of Veritas, and I had the common folk understanding you have the right to record phone calls in Oregon, which you do, which I did. I never committed a crime. Got that? But nevertheless, let's find out why this one-party recording privilege exists. Okay. So, okay, I'm going to read. Let's see, where am I? Okay. So I'm about a third through the case. Defendant argues the police recording of his conversations with Griggs and LaPlante and between LaPlante and Wilson violates Oregon's statutory wiretap law. The first question we address is whether the legislature intended ORS 133.724 and 165.5401A to allow the police to record telephone conversations when one party consents to the recording. Read alone, ORS 165.5401A clearly exempts as a criminal offense that which would be illegal under Chapter 165. Because defendant does not contest that both Griggs and LaPlante gave consent and were participants in the tape communications, the only question before the court is whether ORS 165.5401A exempts from the restrictions of Chapter 133, recorded telephone conversations, where one party consents to the police's recording of the communication. The legislature enacted statutes that set forth the procedure for obtaining court orders for conducting wiretaps under ORS Chapter 133, while the exemption with consent of one party for taping telephone conversations is found under Chapter 165. Thus, the legislature created an exception from criminal sanction under Chapter 165 to acts which are otherwise illegal under that chapter, but did not enact an exception other than by warrant for interceptions under Chapter 133. These statutes can be read as unrelated to each other or to conflict if it is assumed that because ORS 133.724 makes no mention of consent and makes no mention of ORS 165.540, the provisions of ORS 133.724 are to exist independent of the provisions in Chapter 165. That is, there is a conflict if Chapter 165 merely provides criminal sanctions and exceptions from sanctions, leaving ORS 133.724 otherwise efficacious. Simply stated, the language of the statutes does not resolve the issue before us, nor does prior case law interpreting these statutes. In State v. Underwood, 293 or OR 389648 P2D 847 1982, this court interpreted these statutes and allowed evidence of a police officer's taped conversation with defendant. The issue in Underwood was whether an undercover police officer's recording of a telephone conversation between himself and a suspect constitutes an interception which is subject to suppression because it was not obtained under court order. The state contends that the various provisions relating to interception of communications codified in Chapters 133, 165, and 41, which were passed as parts of the same act, must be read together to determine what constitutes an unlawful interception subject to suppression for failure to obtain a court order. Since parties are exempt from criminal liability, the state's position is that communications to which an officer is a party are not unlawful interceptions and need not be authorized by court order. Defendant contends that the provisions of ORS Chapter 133 concerning interception of communications must themselves be read as a whole, and that those provisions conflict unless party communications are subject to suppression if obtained without a court order. 293 OR at 391648 P2D 847 footnote omitted. This court held that no interception occurred, finding that a reading of the interception statutes as a whole makes it clear that no interception occurs when one party records a telephone communication. Thus, this court has interpreted these wiretap statutes as inapplicable to a conversation between a police officer and a defendant. But Underwood does not answer the further question of the legality of recording a conversation between a consenting third party and a defendant when the police are listening and recording the conversation. Dictum in Underwood would indicate that such a procedure would be an interception. Our result is supported by the following interpretation of the term interception in Billecci, it's B-I-L-L-E-C-I versus United States, 87 APPDC 274184 F2D 39424 ALR 2D 881 1950. We think that interception of a phone call necessarily involves the idea that the speaker thinks he is talking to one person, whereas in fact a third person is listening. 293 OR at 393648 P2D 847. We assume that the recorded conversations in this case fall within the prohibitions of ORS 133.724 at SEC, S-E-Q. It's Equincia probably, because the statutory language of ORS Chapter 133 or 165 does not resolve the issue before us. We must turn to the legislative history of those statutes to determine if the exemptions in ORS 165.540 are applicable to Chapter 133 and how the police's recording of conversations between two non-police parties where the police have obtained the consent of one of the parties. Oregon 165.5401A remains in its originally enacted form, and this is history, but the legislative history supports the conclusion that ORS 165.5401A was intended to allow anyone, including a police officer, to tape record a telephone conversation if one party of the telephone conversation consents. A review of the legislative history shows that when the legislature adopted the prohibitions contained in ORS 165.540, the intent was to curtail wiretapping except under limited circumstances, but not to prohibit recording telephone conversations with one-party consent. In other words, the legislature intended to exempt taping or obtaining telephone conversations by third parties where one party consents from prohibited activity described in ORS Chapters 133 and 165. To demonstrate the legislative intent of this state's wiretap statutes to permit recording telephone conversations with one-party consent without a warrant, we start with the legislature's first effort and bring the statutes to their present form. In 1955, Senate Bill 165 was introduced in the Oregon legislature and subsequently passed in amended form. In its unamended form, the bill prohibited a person from obtaining a telephone conversation when the person was not a participant in the conversation. The proponents of the bill were concerned about the increasing use of wiretaps, and the bill was intended to stop the practice by making it a criminal offense. After debate about the feasibility of a blanket prohibition, amendments were proposed which would allow a wiretap with a court order and the obtaining of telecommunications when consent is given by at least one participant. First, Senate amendments to SB 165. The consent language used above is the language that is presently in the statute. This change was made after testimony concerned many problems with the bill, but no specific reference was made to the reason for the consent provision. The procedures for obtaining a court-ordered wiretap were originally part of ORS 141.720, later renumbered 133.724, now 133.724. Note to self, I need to have a discovery request of my consent for the phone call, which I gave to the harbor in a written form prior to the phone call. The combined effect of ORS 133.724 and 165.5401A made it a crime to wiretap without a court order, but specifically excluded the obtaining of telephone conversations with one-party consent from the criminal provisions. The 1959 legislature expanded the activity made illegal under ORS 165.540 to include tape recording of face-to-face conversations. The changes were originally contained in Senate Bill 215. In its first form, the bill proposed amending ORS 165.5401A to state that a person could not record a telecommunication unless express consent was given by all participants. During the testimony on the bill, Senator Corbett questioned why the term all participants was stricken from SB 215 and why in the amendment only one participant needed to consent. The reason given for allowing one-party consent to remain in ORS 165.5401A was to continue to permit the use of that procedure in criminal investigations. Alexander Brown, city attorney of Portland, gave the example of the police officer listening in on a ransom calls in a kidnapping case as a reason why the one-party consent exception to the prohibition on listening to telephone conversation was necessary. Minutes, Senate Judiciary Committee, April 16, 1959. Senate Bill 215 subsequently was replaced by SB 531, which deleted the proposed changes to ORS 165.5401A and left the exception for the one-person consent of telephone tape recording intact. Senate Bill 531 did incorporate the language from SB 215 concerning face-to-face recordation of conversations, including the requirement that all participants consent. This became ORS 165.5401C, and is the language of the present statute that got definitely obliterated by Project Veritas versus Schmidt. In 1961, that's my parenthetical update as of July. In 1961, the legislature allowed an exception to the face-to-face recording to permit the police to use body wires to in investigation of drug cases. Oregon Laws 1961, Chapter 461.1. No change was made or proposed to the consent provisions of ORS 165.5401A. In 1979, legislature made some major changes to Oregon's wiretap statutes to bring them into compliance with federal law. The legislation was proposed after an interim committee studied the problem. The committee discussed the inconsistency between ORS 165.5401A and C, stating, under ORS 165.5401A, interception or recording of either a telecommunication or radio communication requires the consent of only one of the parties of the communication. Under ORS 165.5401C, however, before a face-to-face communication can be intercepted or recorded, all participants must be specifically informed that their conversation is being obtained. This latter prohibition on recording of face-to-face conversations means that a person who tape records a public meeting, public speech, or classroom lecture without specifically informing all participants that a discussion is being taped is guilty of a Class C felony. Interim Committee Report, page 32 and 33. And like, for the record, I was recording anthropology lectures in 2009 in Los Angeles with, like, no felony charges. I mean, I think the professor was somewhat shy, but he needed to get over it. To resolve the problem presented by this inconsistency, the committee proposed that face-to-face tape recording be allowed with the consent of one person. This was originally part of Senate Bills 1 and 484. However, the Judiciary Committee dropped this part of the bill because it was too controversial. Minutes, hearing Senate Judiciary Committee, June 19, 1979, statement of Ms. Godwin. Minutes, House Judiciary Committee, June 30, 1979, statement of Mr. Kelly. Senate Bill 484 passed in amended form with many changes to the procedures for obtaining wiretapping orders, but retained ORS 165.5401A and C without change. In sum, the legislature chose not to allow recordation of face-to-face conversations with one person's consent, but the legislature did not restrict taping or recording of telephone conversations by anyone when one party consents. In 1983, the legislature reviewed the recordation of conversations, enlarged the crimes for which the police could record face-to-face conversations to all felonies, including a requirement that the police first get a court order. These changes are now codified in ORS 165.5405A and 133.726. Again, the provisions required all participants to consent to recording face-to-face conversations unless there is a court order to allow otherwise, but they left recording one-party consent telephone conversations unchanged. From the above, we conclude that the police listening with Griggs and LaPlante's consent to the telephone communications between Griggs and defendant and between LaPlante and defendant was not in violation of state statute. Let's see. We now address the issue of the face-to-face wire recorded conversation between LaPlante and Wilson. Defendant contends that the statements of Wilson that were made in his conversation with LaPlante and recorded by her should have been suppressed because the court order allowing the recording of that conversation was obtained under ORS 133.726, and that statute is unconstitutional by being less restrictive than the federal standards imposed by Title III of the Omnibus Crime Control and Safe Streets Act of 1968. Oregon Revised Statute 133.726 requires a court order for the obtaining of any conversation under ORS 165.5405A. Defendant's argument is that the order should have complied with the stricter requirement of ORS 133.724 in order to comply with the federal law. We agree with the Court of Appeals that even if he is correct in that contention, the federal law does not require a court order when one of the participants consents. Section 2511 of the federal statute contains a number of exceptions, including, it shall not be unlawful under this chapter for a person acting under color of law to intercept a wire or oral communication where such person is a party to the communication or one of the parties to the communication has given prior consent to such interception. 18 U.S. Code 2511 2C 1982. ORS 165.5405A and 133.726 provide a stricter, not less restrictive, standard for recording face-to-face conversations. The Oregon statutes require a court order unless all parties consent. The federal statutes do not when one of the parties consents. ORS 165.5405A provides the prohibitions in paragraph C of subsection 1 of this section do not apply to a law enforcement officer who uses a listening or recording device, machine, or apparatus pursuant to a court order issued under ORS 133.726 to obtain a conversation between the officer or someone under direct supervision of the officer and a person whom the officer has reasonable cause to believe has committed or is engaged in committing a felony, so long as any officer who records the conversation does not intentionally fail to record and preserve the conversation in its entirety. However, the court order shall not be necessary under this paragraph if exigent circumstances make it unreasonable to obtain the court order. The police had obtained a circuit court order under ORS 133.726 to record this conversation between LaPlante and Wilson. Accordingly, the taped conversation between LaPlante and Wilson was not suppressible for the reasons argued by the defendant. The decisions of the Court of Appeals and Circuit Court are affirmed. An ex parte order for the interception of wire and oral communications may be issued by any circuit court judge upon written application made upon oath or affirmation of the individual who is the district attorney for the county in which the order is sought. The application shall include the name of the district attorney, the identity of the investigative or law enforcement officer making the application, statement demonstrating there are reasonable grounds the individual is committing or has committed or is about to commit a particular felony, murder, kidnapping, arson, robbery, bribery, extortion, or other dangerous crime dangerous to life and punishable as a felony, or any conspiracy to commit any of the foregoing crimes, a statement of the details of a particular crime, particular description of the nature and location of the particular description of the type of wire or oral communication sought to be intercepted, the identity of the person if known, suspected of committing the crime, whose wire or oral communications are to be intercepted, a full and complete statement as to whether or not the investigative procedures have been tried and failed, or why they reasonably appear to be unlikely to succeed if tried, a statement of the period of time for which the interception is required to be maintained, if the nature of the investigation is such that the authorization for interception should not automatically terminate when the described type of wire or oral communication has been obtained, a description of the facts establishing probable cause to believe that Additional communications of the same type will occur thereafter. A statement as to whether any prior application has been. Okay, so did you enjoy that, guys? So did you get it? What I get out of that is one-party consent. Well, besides this conflict with 133.574, is it? Which is fascinating in itself. 724, 133.724, and then 165.540. It's really fascinating. And then maybe I also need to read to you this crazy statute, just so you kind of get the law around it. 165.540. And I think the critical line that is under contention regarding Veritas versus Schmidt is the final sentence of the actual decision. Let's see. All I ever wanted was you. Okay, so here we go. Let's see what we say. Oh, okay, wait. That's the dissent. I don't want the dissent. Who cares about the dissent? Okay, where does it wrap up? Is it page 40 or is it 43? Okay. Reversed and remanded. Okay, applying Oregon law, we may not sever the exceptions because severing them would not render section 165.540(1)(c) constitutional. Accordingly, we conclude that the statute is facially unconstitutional. So the final paragraph of reversed and remanded, the prevailing opinion of the three-judge panel at the Ninth Circuit. Reading section 165.540(1)(c) as a whole, we conclude that it is content-based speech restriction that cannot survive strict scrutiny because Oregon has not asserted a compelling government interest and because the statute is not narrowly tailored. The statute is also not a valid time, place, or manner restriction because it does not leave open ample alternative channels for communication. Applying Oregon law, we may not sever the exceptions because severing them would not render section 165.540(1)(c) constitutional. Accordingly, we conclude that the statute is facially unconstitutional. Let's see, I'm going to read this footnote. The dissent argues that the legislature would want to retain section 165.540(1)(c) as a standalone provision, even if the exception in section 165.540(5)(b) for recording police officers were severed, because the general prohibition in section 165.540(1)(c) was freestanding for 56 years before the legislature adopted the exception that allows the recording of law enforcement officers performing official duties in public. Dissent at 51, see also dissent at 67, 68. This is neat that the prevailing opinion still keeps referring to the dissent in their footnote. This evinces a misunderstanding of the relevant legislative history. The legislature adopted section 165.540(1)(c) long before Fortescue made clear that such a general prohibition on filming matters of public concern raises serious constitutional questions. C55 F3D at 439. Following Fortescue, that's FORDYCE, and subsequent opinions reiterating this rule, the legislature added the exception in section 165.540(5)(b), likely to eliminate this constitutional concern. Unfortunately, the addition of this exception rendered section 165.540 a content-based speech restriction, which created a different First Amendment issue. Given that the Oregon legislature already evinced its intent to avoid the constitutional questions raised when section 165.540(1)(c) was a standalone provision, we must conclude that the legislature would not sever the exception in section 165.540(5)(b), which would merely bring back to life the same constitutional issue that the Oregon legislature faced prior to enacting this exception. Okay, then I'm just going to go back to this sort of like 2 paragraphs before the final paragraph to see if we can kind of get the momentum. If the exceptions were removed, section 165.5401C would raise serious constitutional issues. This section would prohibit the unannounced recording of police officers performing their official duties or a felony endangering human life. But we have consistently and repeatedly held that the First Amendment protects the right to photograph and to record matters of public interest. At 1044, which includes the right to observe government operations, Reed v. Lawrence, and the commission of a crime, see Obsidian Fin Group LLC v. Cox, requiring a citizen to inform all parties involved to capture government officials' performance of official duties in public places, for example, would substantially impede the speech right by foreclosing a major avenue for citizens to gather information about government officials in an unaltered form that can readily be disseminated to others. Despite the fact that this type of speech serves as a cardinal First Amendment interest in protecting and promoting the free discussion of government affairs, Glick v. Cuniff, citing Mills v. Alabama, further, an unannounced recording of a felony in progress would not only tend to reduce the opportunity to capture such evidence, but also tend to imperil the person recording. Given the impetus for this exception was to enable police officers to make unannounced recordings of felony drug transactions and felonies endangering human life without first obtaining a court order, the legislature would not choose to endanger police by eliminating this exception to the general rule. The dissent suggests that removing the exceptions from the general prohibition in section 165.5401C would not raise constitutional issues. Okay, there we are. Because a court would likely deem section 165.5401C unconstitutional as applied to an individual who filmed police or other matters of public interest in public places. Dissent at 68-69, but such a conclusion merely acknowledges the general prohibition itself raises serious constitutional issues. Therefore, severing the exceptions that make the general prohibition content-based and extending the general prohibition to these protected First Amendment activities would create significant constitutional others rather than cure them. Under outdoor media, we must presume that the Oregon legislature would not retain such a law. Oh boy. Wow. And then this issue of severability, there are so many overlapping exceptions. They're talking quite at length. It cannot be stayed. Okay, because we conclude that section 165.5401C is not a valid time, place, or manner restriction, it cannot be saved by striking the 2 exceptions at issue here. Therefore, severability is not germane. Bernstein Bros 661 P2D at further, under outdoor media dimensions, we also conclude that the Oregon legislature would not intend the exceptions to be severed because when Oregon courts analyze severability, they assume that the legislature prefers to avoid enacting a bill that raises serious questions of constitutionality. For this reason, the dissent's argument that a parade of horribles will result from our analysis, such as the invalidation of eavesdropping statutes, is not well taken. As explained, see supra section 3A, the threshold question is whether the challenged law restricts First Amendment protected speech. Under Wasden, the creation of unannounced recording is speech protected by First Amendment, but we are not aware of any cases holding that eavesdropping without more is protected speech. Therefore, the First Amendment would not constitute grounds to invalidate a statute prohibiting that conduct. Moreover, we analyze section 165.5401C as a prohibition of First Amendment protected speech in public places. See supra section 3C. Our analysis of the state's asserted governmental interest and whether its restriction on speech is narrowly tailored would necessarily be different in the context of eavesdropping, where an individual's heightened privacy interests in his own home are at stake. Nothing we have said today impugns the well-established rule that the First Amendment does not accord a speaker immunity from torts or crimes committed in the service of speech. Torts. So back to civil court, guys. Sue me. Moreover, the dissent's reliance on Dietman is misplaced. Dissent at 55, 56, 62, and number 1165. In Dietman, 2 journalists used the ruse to gain entry to the plaintiff's home and then surreptitiously photographed and recorded him without his consent. We held that the plaintiff could state a claim for invasion of privacy under California law because the conduct occurred inside the plaintiff's home and because the First Amendment did not accord newsmen immunity from torts or crimes committed during the course of news gathering. But Dietman has no bearing on the question of whether a rule prohibiting unannounced recordings in public places fails to leave open ample alternative channels of communication. So in terms of, it appears Ron Brown charged me with, wanted to kind of imply that I broke 1C, this 1C, which was invalidated definitely by Veritas versus Schmidt, Lamborg, and I think the entire statute is quashed by Veritas versus Schmidt, but Ellen Rosenblum, who was a party, is trying to salvage what she can of 165.540, and I believe it's under appeal also. So while this is being decided, it's a kind of absurd to even be charged under, or furthermore recharged after the section you wanted to charge got definitely obliterated, which is what Ron Brown did both in my case and the Emily Reinicke case. So that itself is very disingenuous and double jeopardy. It's like, to me, it's very disrespectful of the federal decision. But in regards to trying to say, oh, well, yours, because mine is both a public place, it's a 1C category and conceivably a 1A category. I'm the one who gave the Harbor Advocate the consent to make the call on my behalf. She then gave me consent to be the participant of the call that I gave her consent to make. And she announced my presence, which is more than the police get when they are secretly recording or kidnapping ransom phone call. And she announces my presence, announces that I'm here, announces that I want this clothing voucher fulfilled. So I am prosecuted for going to a domestic violence center, giving consent to my advocate to advocate with this unreasonable, sexually harassing felon with a firearm who is verbally abusive and completely rebellious against the civil rights violations that have been pointed out to him regarding disability discrimination and gender discrimination, and he's doubling down in his discrimination. I record a tiny little snippet of it to help other victims of his oppression and his discrimination have proof that this is his normal modus operandi. I get the wiretapping charge even though I have one-party consent rights for this phone call. And that's the Veritas attorney believes I definitely had the one-party recording rights, which is exactly what I told Hansen on St. Patrick's Day when Ozark's little case got launched. Why did Hansen not know that? Was it because he wasn't in the room, because he doesn't understand the context, or because they were just eager to smash me down and intimidate me? Or they're irritated that I reported Chris Duffy of Meals on Wheels for sexually assaulting me? Or they irritated at me for reporting a lifeboat client for putting his hand around my throat repeatedly? What is it that makes me so easy to be targeted? And one thing I suspected, which sounds rather paranoid and conspiratorial, is, well, if Ozark wants to prosecute me, let's go ahead, because Mary Ang is going to fight really hard and expose your wrongdoing more. And I really did sort of think, oh my gosh, am I being used as a pawn in a game to bring down Lifeboat? Because that makes me just sort of like an unwitting agent, for I have to defend myself clearly. And why is the state refusing to see the bigger picture of the abuse? Oh, because women are completely marginalized? Oh, because homeless are completely marginalized? And I hope this case actually helps them think a lot. And then the Reinicke case seems to have different circumstances. KGW reporters seem to point out that the transit case got dismissed, which originates with John Ewan, the disgusting meth dealer from Seaside, chasing down her bus, and she was the victim of a crime. And once again, the district attorney is persecuting a victim of a crime. It's really, the whole thing is so offensive. But I hope you enjoyed the confusing 165.540 analysis. And I really do cherish the one-party recording permission. And I've tried to point out to the state, this is for you guys. Don't relinquish your powers. You don't have to get warrants. Like, you're prosecutors. You should love this statute. You should defend this statute. And having to tell them that this is their law, don't try to knock out your law or reduce the scope of this law. It's not in the state interest, in your state interest as a prosecutor, to reduce the potency of the 165.5401A. If it's debatable that Veritas has smashed it anyway, and the legislature needs to figure this out and come up with a better law that isn't basically sort of like a house with many additions that are all like patchwork. It's like it starts in the 50s, it gets adds on, it has different changes and permutations suiting the times, and the law is absolutely out of date in terms of conformity with any of the newer technologies that have emerged. Many phones preemptively record all phone calls, and people with hearing aid assistant disability needs, their phones get recorded and transcribed. Like the Google Pixel, my friend who has that, who's hearing disabled, she has a most amazing capacity to have printed transcripts of phone calls immediately. And my friends have been telling me about apps that do this. So the law is really stuck in the Stone Age. And it's very, very Stone Age. For me to go into a domestic violence center and the staff of the harbor expect me to be quiet while I'm being verbally abused by Ozark, because at the time they were saying, well, we're trying to work with him and we're trying to partner with him and we try to work with abusers and bring them along like little wounded birds. Okay, but you are supposed to advocate against me being abused, me being discriminated against, and maybe that was beyond their vision at the time. Hopefully it's not now. And what I found out is the director of the harbor is on medical leave. I don't know if this case has anything to do with it, but it's pretty disgusting that the district attorney wants to prevent me from obtaining domestic violence services as a punishment for my critique walking into the public place of the domestic violence center and seeing that they expect me to be verbally abused by Ozark Iraq and stay quiet about it and keep his dirty secret. I think it's... And what about their $1 million budget? Does that make prosecuting me like, oh, well, let's protect the $1 million budget of the harbor? Anyway, I've got to go get my laundry out of the dryer. Bye.